and welcome to a newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hi, Richard.
That was very loud, Lizzie.
Sorry, I just moved the microphone too close to my face. Just waking you up on this Monday afternoon.
Yeah, I've been doing courses this morning and lunchtime.
So we are here because we did a webinar on restrictive and positive covenants and commonhold, and we had loads of questions, as is becoming the case with our webinars because we've had so many people on them. I think this was one we had over 4,000 people signed up for. So understandably, in an hour, we can't cover all of the questions. So we're going to attempt to get through the rest of them on this podcast episode. And we're going to start by talking about some of the questions in relation to restrictive covenants and in particular dealing with enforceability. So question number 1, do the 4 requirements for the burden of a restrictive covenant to pass at equity derive from Tulk and Moxhay?
Tulk and Moxhay, that takes me back to my land law lecturing days. The answer is not really no. Because Tulk and Moxhay was the case that sort of first recognised in equity and not by law restrictive covenants and property rights. We did a podcast on it, one of our top cases. You remember that, Lizzie, years back?
Yeah.
Yep. And Leicester Square, Leicester Fields, as it was at the time. Well, because the 4 requirements are that it's got to be a dominant and servient tenement, and the covenants must touch and concern the dominant land, and they must be restrictive in nature and must have been intended to pass for the land. Tulk and Moxhay itself was a development of easements where there's got to be a dominant and servient tenement and a benefit to the dominant tenement. So to that extent, yeah, there were a development of easements, but the real sticking point, the real problem area, the fact they've got to be positive, they can't be positive, covenants, they've got to be restrictive in nature, if I said otherwise, came from a subsequent case, Austerberry and Oldham Corporation, which was a sort of backpedaling from Tulk and Moxhay itself. The requirement that they must be, well, basically, historically, if you're a bona fide purchase of a value without notice of them, which is since 1926 for covenants, subsumed in various aspects of registration, actually derives from equitable rights generally, which don't bind a bona fide purchase of a value of a legal estate without notice. That's a bit of history for you.
We like a bit of history on the podcast. Are we ready for the next question? Yep. So the next question, in terms of benefiting land, does it need to be immediately adjoining?
Not necessarily. I think a good test is, does it make the dominant land a more valuable place, so it doesn't have to be completely adjoining. Nearby, if it's 5 miles away, there's no benefit. Not exactly completely adjoining.
If the benefiting land has a new owner, can they enforce even if the previous owner allowed breaches?
I mean, it's difficult. It's a question of degree, really. I mean, if the breach has occurred for 20 years, probably, but possibly less than that, and it's been an open breach, the covenants won't be enforceable at all. There is a potential for sort of an estoppel claim if the previous owner allowed breaches. There was a case on the easement, similar kind of thing, ERI's investments in higher, remember. But question of degree, really, that one.
And what happens if the benefiting land has been adopted as public highway?
Well, basically, if it's, I presume you mean that the council's not the person with the benefited land. If it's been adopted and all you've got is the undersoil, the subsoil underneath the adoption, the scrapings and materials, as they say, then that wouldn't be enough to have a benefited piece of land. One of the classic cases on the restricted covenants on that, Kelly and Barrett from 1924.
I think the next question is very similar, but how about benefiting land under an adopted highway where the owner is also the local highway authority?
No, it's not necessarily similar. There was a case which was never fully reported and decided finally on different grounds called North Foreland and Ward, which you'll find in Jessel's classic book on overage clauses, a must read for anybody during the summer holidays which are coming, and which suggested that even private roads wouldn't be enough for the benefited land. I think the jury's out on that one. if it's local authority who's trying to enforce the covenants. I'm not sure there's a full answer to that one, actually, Lizzie.
How are neighbours who hold the benefit of a restrictive covenant made aware that they have it?
Well, it depends on, well, if it's registered land, it should feature on title of the notice. And if it's unregistered land, it should be a D2 land charge if it was created from 1926, January the 1st onwards. If it was prior to that date, you could have constructive notice. If it's referred to in the deeds, that would be constructive notice or actual notice or imputed notice of your agents.
If a purchaser for value takes free of a covenant, is it extinguished or could a later purchaser be bound?
Well, purchaser for value will only apply to covenants were created before the Law of Property Act came into force on January the 1st, 1926, 100 years and more ago now. What a celebration it was, the 100th anniversary this New Year's Day. But but in that situation, once it's extinguished because you're a purchaser for a legal estate for value without notice, it'll be extinguished forevermore.
What about boilerplate clauses stating the transferor includes successors in title?
Yeah, I mean, I presume that's getting at the fact the City Inn 10 Trinity Square case, which I don't think I went through in great detail when I did, Margison and Bates, that it says if it's just the transferor has to consent, for instance, without mentioning successors, it is just the transferor. And successors can't enforce just the transferor. And if the transferor doesn't own any land nearby which is benefited, then the covenants, well, basically can't be enforced to all intents. But usually you state that the transferor includes successors in title, and that would clinch it. It's only where you, I mean, City Inn in 10 Trinity Square was a bit different because there was a series of covenants. It was sale of Port of London Authority's headquarters, as they were, near on Tower Hill, near the Tower of London. And there were various covenants, some of which said that the transferor has to consent to plans. So by implication, the ones that transferor and their successors has to consent to plans. By implication, the ones that didn't say that didn't pass the successors. But like you say, you have a boilerplate clause which deals with it.
How does this apply where there's a parent company and subsidiary structure?
It depends on the word, and again, if it's a named company or a named individual without making successors, the argument goes it's just that named company or named individual. There was one called Churchill and Temple, a case where it was a named surveyor, for instance, and once the surveyor's dead, then the covenants die with them. But if you mention successors, you've solved the problem.
Brilliant, thank you. So the next questions are about what happens when covenants are breached or challenged. And the first question is, can a covenant of building line be enforced if its exact location is unclear or the company no longer exists?
Well, if the company no longer exists, it depends on what we just talked about, whether the covenants of the benefit of the transfer, including successors or not. If you can't find, if you can't identify the benefited land, it's a bit like that case, the Bath Rugby Club and Greenwood case. If you can't identify the benefited land, then the argument goes that the covenants can't be enforced for that reason.
Next question is, are there arguments based on the doctrine of laches?
Yeah, basically, because it's an equitable doctrine, so it's in relation to equitable remedies, like injunctions, most obviously, and restrictive covenants. It means delay. If you've delayed, because it's things like injunctions and specific performance, but injunctions here are discretionary remedies. And if you delay for a sufficient amount of time, you won't get the injunction. You can still get damages.
Can restrictive covenants be challenged or discharged under Section 84 of the Law of Property Act 1925, possibly what the questioner meant by Section 33?
I think I understand it. Yeah, Section 84 of the Law of Property Act, you can go off to the upper tribunal to discharge covenants into the Lands Chamber upper tribunal on various grounds. Most notably, they're obsolete or they prevent reasonable use of the land and don't secure any practical benefits or they're contrary to public interest. And there's lots of cases where covenants are discharged and modified. The Section 33 point, I presume they mean Section 33 of the Local Government Miscellaneous Provisions Act of 1982. which has been very little litigated. The predecessor went back to the Housing Act of 1974, Section 126, and there's been very little litigation. But if you actually look at the Section 33, and this is not written in stone, it seems to apply only to positive covenants. You can discharge positive covenants. So it does talk about sort of, covenants regulating the use of land as well, which could be restrictive user covenants. But the jury's out on it. But if it only applies to positive covenants, it's a way of enforcing positive covenants by local authorities against third parties. Then my bet is no.
Okay, next question. What happens to restrictive covenants when land is acquired through adverse possession?
Well, if it's unregistered land, it's not something I dealt with really, but it's one of the older cases on adverse possession. And if title's not registered, it's Reed Nisbet and Potts contract from 1906, I think, which basically says that restrictive covenants will still be binding. If you adversely possess the land, you'll be adversely possessing subject to restrictive covenants. If it's registered land, it's in Schedule 6, paragraph 9, subsection 2 of the Land Registration Act, which basically says that adverse possession doesn't affect any other interest in relation to land. Interesting, paragraph 9.3 makes an exception for charges you'll take free of. And there was also a case on the registered land spectrum investments in homes, which basically said that intermediate leases, if you adversely possess, leaseholds, then the leases will be discharged as well.
And what happens if land is compulsorily purchased? Are covenants extinguished?
If you compulsorily purchase land, you can also compulsorily purchase covenants and easements under Section 203 of the Housing and Planning Act of 2016. It used to be a predecessor in Section 237 of the Town and Country Planning Act. And you basically compulsorily purchase them, and you pay compensation based on compulsory purchase under Section 204. It should be a last resort. There was a case involving Leeds City Council and Leeds Cooperative Society, which made it quite clear it's a last resort, else you might have human rights claims on your hand and the likes. So you should be going there on the route of Section 84.
Okie dokie. And the next one, can successors of that company still enforce or give consent?
It depends on whether you've said that the covenants are for the benefit of the transfer and also successors or not.
And final question in this kind of little section, do you assume pre-1977 covenants are enforceable even if the land charges search is clear?
I don't think I'd presume it. I mean, basically, the thing is, if you got a covenant created from 1926 onwards and prior to the conveyance that triggered first registration, it should be protected as a D2 land charge. And if it isn't, a purchase of a legal estate for money or money's worth will take free of it. Money's worth being marriage consideration. But it's the effect of Section 4 of the Land Charges Act and Section 198 of the Law of Property Act. And if that's the case, then you should be free of it, even if it shows up after first registration on the register. Unfortunately, the Land Registry were busily destroying details of land charges and the likes until 1977, when they perhaps realised they shouldn't be. So it's not a watertight thing if it's a pre-1977 or 1977 or beforehand covenant. But it should be watertight if you've got a clear land charges cert, even if it's registered land and the covenants were created from 1926 and prior to the conveyance that triggered first registration. If there's no D2 land charge, you should be able to remove them. I have actually seen the Land Registry saying that if it was a voluntary first registration, that wouldn't apply, but I'm not sure they're right on that.
Okay, next question. If a covenant is expressed as personal to the transferor, but they move away, how does annexation work?
Well, that's that City Inn case, again, in 1026 Square, which is what basically happened there. They all moved to Dartford. And the covenants wouldn't be annexed to the land if it's personal. The original covenantee with the benefit of the covenants could be enforced, but they've got to have some benefited land. And if they're in Dart, they're trying to enforce covenants in Tower Hill, there's no benefited land.
Okay, thank you. On to positive covenants now, which was another part of this webinar. What happens where a road maintenance obligation exists, but there is no express covenant?
Well, maintenance is a positive obligation, so it's not a property right which automatically passes with the land. One way of sort of maintaining private roads and things is by deeds of covenant and restrictions. Every time you come to sell, your purchaser has to enter into a direct covenant with the person enforcing, and they can't become registered proprietor without that. There's a restriction against it on the title. If it's not there, then you could try estate rent charges, which sort of are still used in conjunction with the fact that you've got a right of entry and the ability to create any duration lease if the money is not paid, but towards maintenance. But the government's in the draft Commonhold Leasehold Reform Bill one day say they're going to get rid of that. Section 121 of the Law of Property Act. You can sue in debt. You could sue for breach of contract. You could have a clause in the agreement allowing you to sue. You could bring a statutory demand for bankruptcy.
Okay, thank you. Next question. Is overage enforceable indefinitely, or is there a time limit?
Well, it comes subject to perpetuities. If the covenants were created, there's just been a recent case that we may just do a podcast on, Crest Nicholson and Calvert, about the rule against perpetuities. But I won't even try to go into the rule against perpetuities as it existed prior to April 6, 2010, when the Perpetuities and Accumulations Act of 2009 rewrote it. But it comes within, we usually had a statutory perpetuity period under the 1964 Perpetuities and Accumulations Act of 80 years. The Section 5 of the 2009 Act is an automatic perpetuity period of 125 years. Did you know that the only academic article I ever wrote at university was on the rule against perpetuities? And I decided I only just started. And I decided on the rule against perpetuities because I knew no one would read it, so no one could contradict me.
What, because it's so boring?
Well, it's just so complicated, incredibly complicated. But so I chose that. And I'm now quoted in the textbooks as an expert on the rule against perpetuities.
Didn't know that. If a restrictive covenant is used to extract money, overage, could the court set it aside?
If there was a case, it's not in the notes actually, about Cosmico and Southampton City Council, which I do mention in overage courses, that was basically council prepared to release an overage clause if you paid a development charge, and because of that, the court decided it was personal and therefore not binding on the land and unenforceable. And I think that's what it's getting at. There was a case called Gafford and Graham as well in 1998, I think, which said that if you're prepared to accept money, the covenants will be discharged. You'll have to pay damages, but it suggests that you will, don't necessarily want to have the covenants binding. But there are other cases. I mean, there was Graham and Easington District Council, which is all about sort of overage if you came to, supported by restrictive covenants, if you, in relation to council house right to buys, and if you get planning permission to build, anything other than a single dwelling, give us some money. And the court decided that that would be void because the Housing Act 85 envisages that when you buy your council house, you should be free to make a profit and a loss on it. So, but no, I don't think it's a definite rule, but Colton and Southampton City Council is a bit of a death knell to overage and restrictive covenants. I don't think they should be used for restrictive covenants anyway. I don't think restrictive covenants are a very good way of enforcing overage.
You heard it here first. Moving on to building schemes. What about estates with private roads where each transfer requires covenants, but the building scheme isn't expressly stated?
If it's not expressly stated in this day and age, it's probably not a building scheme. There's a case called Birdlip and Hunter, in 2016, a Court of Appeal case that said it was all about sort of pre the First World War, various 20-odd houses being built around Gerrard's Cross. common, and all had covenants on them, but different covenants. And the Court of Appeal said to be a building scheme, it must be certain, which probably means it's in the deeds, initially. I don't think they're as common as people might imagine.
Okay, thank you. Is overage technically a restrictive covenant?
It can be a way of enforcing overage, but a better bet is positive covenants and restrictions, not least of which because of what I mentioned with Cosmocombe and Southampton. Also, you can go off to the upper tribunal under Section 84 of the Law of Property Act to discharge it. Restrictive covenants, but not positive covenants, backed up with restrictions. The difference between the two is that, overage is basically securing additional money at a later stage. You shall not build, give me some money and we'll discharge the covenant. Is overage, a kind of negative overage, restrictive covenant. If you get planning permission, give me some money, some of the betterment value, the additional value is a positive covenant, which is a much better bet as a way of enforcing overage for various reasons that we've probably mentioned.
And how does Section 121 rent charges survive the Tenant Fees Act of 2019?
It's a rent charge as opposed to rent under a lease, which is strictly called rent service. It's something which is annexed to freehold land eventually, and so Tenant Fees Act doesn't apply to it.
Okay, moving on to Commonhold reform in the final minutes of the podcast. How will positive obligations be enforced under Commonhold?
Basically, because all the various parties to Commonhold, members, unit holders, and the Commonhold Association agree a community statement, which you can add, which is fairly pro forma. You can add local rules, and positive covenants will be enforced by the community statement. It's a bit like a lease to all intents, but it's in freehold. Positive covenants and leaseholds can be enforced against third parties.
What happens if a Commonhold association is wound up?
Well, that's one of the reasons they never took off back in September of 2004 when it all came in, because if they were struck off for not producing accounts or confirmation statements with Companies House, you'll have a load of, if it's flats, you'll have a load of freehold flats, flying freeholds. There is provision in the draft bill that anybody can apply to court for a new directors and a new Commonhold association. I think to some extent it presupposes that people actually do a lot of work, in sort of, and sort of prepared to spend lots of time actually doing the work, sort of managing the Commonhold in the absence of some managers doing it.
Can shared ownership leases exist within Commonhold?
Well, at the moment they can't. That's another problem because, historically you won't get planning permission for anything but the smallest developments unless you've got affordable housing. There are provisions in the draft bill to allow, you can't create leases of more than 7 years duration, residential leases in the Commonhold as it stands. In the future, certain leases will be permitted, like equity release in Islamic mortgages based on sale and leaseback with shared ownership. It does say that as long as you can staircase up to 100%, in some of the rural schemes you can't.
Well, thank you very much, Richard.
Okay, thanks, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.